Hello everyone, I'm Marco, and in this video I will explain the main parts of an international contract, based on an example of an international sale of goods agreement seen between a Japanese company and a Mexican company. First, we need to see what is an international contract. Well, an international contract is a legally binding agreement between parties located in different countries. Its structure is extremely important because it provides legal certainty, clarifies obligations, and establishes mechanisms to resolve disputes. Let's break down each section. First, we start with the preamble. The preamble is the opening section of the contract. It identifies who is entering into the agreement and in what legal capacity. In our example, the parties are Asahin Industries as the buyer and Tequilas de la Sierra as the seller. This section also includes the full legal name of the companies, the name of their legal representatives, the notarial powers proving their authority, the city and country where those powers were granted, and the preamble is essential because it confirms that both parties legally exist and that the individuals signing the contract are authorized to bind the company. Next, we have the recitals. The recitals usually provide background information about why the parties are entering into the agreement. They may describe prior negotiations or the commercial purpose of the contract. However, in this specific example, there is no formal recital section. This is acceptable because, recitals are optional. However, in more complex agreements, they help interpret the intention of the parties if a dispute arises. Next, we have the statements, or also known as representations. These declare the legal status and capacity of the parties. In this agreement, the buyer declares it is legally incorporated under Japanese law. The seller declares it is incorporated under Mexican law, and both confirm that there is no legal impediment preventing them from entering the contract. This section is important because false representations can create legal liability between both parties. Next, we have definitions. Many international contracts do include a definition section where key technical terms are clarified. In this agreement, however, there is no formal definition section, but it is important because technical concepts appear within the clauses, such as tariff classifications and the Incoterm CIF. Even without a separate section, clarity in terminology remains crucial. It is optional, but we do advise you include one. Next, we have the clauses. The clauses are the core of the contract. They establish the rights and obligations of the parties. Some key clauses in this agreement include the object of the contract, that is the international sale of 1,500 bottles of tequila, the price, that is $25 per bottle, totaling $37,500. The payment method, confirmed and a revocable letter of credit through HSBC, a bank. The Incoterm, that is CIF in Yokohama, Japan. Delivery deadline, that is November 1, 2007. Penalties for delay, that is 3% discount for the first week and another 3% for the second week. Force majeure clause, no liability for natural disasters, strikes, or unforeseen events. Confidentiality and regulatory compliance. Tax allocation, the export taxes paid by the seller and the import taxes paid by the buyer. The languages, the Japanese and Spanish versions are equally valid, and the validity, that applies only to this specific transaction. These clauses clearly allocate risk, responsibility, and consequence in case of breach. Then we have final provisions. Although there is no separate section titled Final Provisions, the contract includes important clauses that function as such. In this example, Here we have the waiver of local court jurisdiction, dispute resolution to arbitration during the rules of the International Chamber of Commerce, application of the commercial laws of the State of Texas, United States, and termination clauses such as mutual agreement, non-payment, force majeure, or breach of contract. These provisions are especially important in international contracts because they determine how disputes between parties from different countries will be resolved. Then we will have annexes. Annexes usually include supporting documents such as technical specifications, certificates of origin, or detailed product descriptions. In this contract, no annexes are mentioned. However, in real international transactions, annexes are very common and can provide additional clarity. And finally, we got the signatures section, which formalizes the agreement. The seller and the buyer sign the contract, along with witnesses, and the document specifies the place and date of execution, that is Mexico City on March 9, 2008. When signed, the contract becomes legally binding. In conclusion, to conclude a well-structured international contract, it should include clear identification of the parties, legal representations, detailed clauses on price, delivery and payment, dispute resolution mechanisms, force majeure and termination provisions, and proper signatures. Each part serves as a strategic legal function to reduce risk and ensure certainty in cross-border transactions. An international contract is not just a commercial agreement, it is a legal protection tool designed to manage differences in laws, jurisdictions, and business practices between countries. That's it for today. Thank you for watching.